Hello and welcome. This video, Look Over Your Attorney's Shoulder, is number 8 in a series of 10 videos designed to educate Utah residents about estate planning. For a list of all of our videos, see below or return to our website. In this video, we will identify several issues that you should discuss with your estate planning attorney and several points that you should make sure your attorney correctly addresses in your estate plan. For more detailed information, feel free to visit our website at utahtrustsandestates.com. First, an estate planning client should always be clear about what services the attorney's fee includes and what services the fee does not include. For example, the client should ask the attorney who is responsible for funding the client's revocable trust. As discussed in detail in video number 4 of this series, transferring real estate to a revocable trust will require the preparation of deeds. Transferring partnership interests to a revocable trust will require preparation of partnership assignments. The client should ask the attorney if preparation of these documents will require an additional charge. It is also a good idea to ask your attorney how much complexity will there be. A basic estate plan, the centerpiece of which will be a revocable trust, also sometimes known as a living trust, does not generally inject much complexity into the client's life. Initially, the client will need to transfer assets to her revocable trust. On an ongoing basis, the client will be transacting business through her revocable trust rather than in her name as an individual. Most clients do not find the administration of a revocable trust to be especially burdensome. On the death of the first spouse, however, the estate plan may contemplate the creation of one or more irrevocable trusts for tax or other reasons. The creation of these trusts may require the opening of new bank and brokerage accounts and the preparation and filing of additional tax returns every year. The couple should ask the attorney just what will be required after the first spouse dies, and they should make sure that they are comfortable with that plan. Next, even if your estate planning attorney is highly qualified, it is prudent to check his or her work. The following is a list of basic points to keep in mind as you work with your estate planning attorney. Number 1, understand the purpose of your revocable trust. Your attorney will probably recommend that you have a revocable trust as the core document in your estate plan. Be sure that you understand the purposes of a revocable trust, what a revocable trust does and does not do. For a discussion of revocable trusts, see videos 2, 3, 4, and 5 of this series. Number 2, check the gifts. If you want your diamond ring to go to your sister, Mary Jones, $100,000 to go to your friend, Susan Thomas, and everything else to go to your children in equal shares, make sure the estate plan your attorney has drafted clearly says all of that. Make sure it says that the diamond ring is to go to Mary Jones and that $100,000 is to go to Susan Thomas. Before you sign, ask your attorney to show you the specific provisions in the trust that say that. Number 3, what if a beneficiary predeceases you? Your estate plan should explain what you want to happen if one of your beneficiaries dies before you do. Using these same examples, who do you want to receive your diamond ring if Mary Jones predeceases you? Your revocable trust should be specific. Or if Susan Thomas dies before you do, what do you want to have happen to that $100,000 gift? Do you want someone else in particular to receive the $100,000 or not? Your revocable trust should state your preference. Number 4, make sure there's a residuary clause. Check to make sure your revocable trust contains a residuary clause, a provision that disposes of all the rest of your property, the residue. You don't just want an estate plan that gives your diamond ring to Mary Jones and $100,000 to Susan Thomas. You also need a provision in your estate plan that says where everything else goes. Otherwise, as described in video number 1 of this series, It will pass according to the rules governing intestate succession and will probably go somewhere you don't want. Number 5, guardians. If you have minor children, your will should nominate guardians who will be responsible for raising your children. Ask your attorney to show you the specific provision in your will that nominates the guardians. Number 6, funds for minor children. How will your property be held and managed for your minor children if both you and your spouse die? Presumably, your assets will be held in trust until your youngest child reaches adulthood. Make sure your revocable trust clearly expresses your desires. Number 7, fiduciaries. Make sure your revocable trust names the successor trustees you want, and make sure it nominates contingent or backup successor trustees. Similarly, check the executors who are named in your will and the agents who are named in your power of attorney. Number 8, beneficiary designations. Work with your attorney to make sure the beneficiary designations on your retirement plans and life insurance policies are consistent with the dispositive terms of your revocable trust. Make sure your property is really going to your intended beneficiaries in the proportions you intend, after taking into consideration both the terms of your revocable trust and the beneficiary designations on your retirement plans and life insurance policies. Number 9, consider your existing estate plan. If you have an existing revocable trust, your attorney will probably be amending and restating the trust. The new trust should specifically refer to and restate your existing trust. Failure to do so can cause your assets to be distributed in a manner other than what you intend. The new trust must also comply with the procedures that the existing trust prescribes for amendments. Check to make sure your attorney has done all of this properly. Number 10, what will happen after the first death? After the death of the first spouse to die, many couples want the surviving spouse to have unfettered access to all of the couple's assets. But if the spouses have children from prior marriages, they may prefer to restrict the surviving spouse's access to the deceased spouse's assets, perhaps giving the surviving spouse only the annual income from those assets. Ask your attorney just how this will work under your estate plan. Number 11, estate taxes. If there is a possibility that estate tax will be due upon your death, talk to your attorney about how the tax will be allocated among your beneficiaries, and make sure the revocable trust actually provides for what you want in this regard. For example, do you want Susan Thomas to receive $100,000 minus the estate tax attributable to her gift, or do you want her to get the full $100,000 with the estate tax attributable to that gift to be paid from the residue? Number 12, funding your revocable trust. It is important to make sure your revocable trust is fully funded. Talk to your attorney about how to do this. For information about funding a revocable trust, see video number 4 of this series. And finally, plain language. Make sure you understand the language in your estate plan. Remember, if it doesn't make sense to you, it doesn't make sense. Once the estate plan is implemented, it may fall to the client to keep it operational. Ask your attorney if there are any ongoing responsibilities of which you need to be aware. That concludes this video. I hope you have found it helpful. For more information on this topic, you can visit our website at utahtrustandestates.com or call us at the number you see on your screen. If you would like to watch another video in this series, either click on the appropriate link below or return to our website. Thank you.